This conference will now be recorded.
Okay, thank you all for joining us on what will be thoughts on the recent encounters with the conduct system. I'm here today with Zach Greenberg from FIRE, Leah Murphy from Shaw and Murphy, and I'm Bob Platt. We have a nice distinguished audience here of fraternity leaders, and we also have Rocco DiLorenzo, the outgoing president of the AIFC and the current chair of the University Assembly's Campus Codes Committee. We have, I'm sorry, oops. We have three planned presentations, then we'll have a Q&A. Our first presenter will be Zach Greenberg, who is a native New Yorker, and he graduated from Binghamton University in 2013 and Syracuse Law School in 2016. He developed an appreciation for free speech while leading the College Libertarians and the Federalist Society. He happens to be a brother in Pi Kappa Alpha. And then I will talk. I'm Bob Platt. I'm a Deke, and I graduated from the Cornell Law School in 1976. And then we have Leah Murphy, who graduated from Brown University in 1985 with honors in economics, and from the New York University Law School in 1988. He's practiced law for over 20 years in large and small firms. Okay, Zach, take it away, and again, say slide when you want me to advance the slides.
Sure thing. Thanks so much, Bob, and I really appreciate everyone being here to talk about what we think are really important issues facing higher education right now, especially Cornell. So just for starters, I'm Zach Greenberg. I'm a First Amendment attorney at FIRE, the Foundation for Individual Rights and Expression. We're a nonpartisan nonprofit dedicated to defending free speech on college campuses nationwide, in addition to due process and freedom of association. And that is exactly what we're going to talk about right here. What are the free speech, the free association, the due process rights of college fraternities like those at Cornell? We can dive right in with our first slide right here, problems with anonymous reporting. So in general, it's a baseline matter. Student groups have due process rights. They are just like students. They cannot be de-recognized or punished or otherwise suspended unless the university provides them with the proper procedures. And Cornell, based on FIRE's due process report, actually has pretty good policies and procedures. They generally require students, or they generally require their administrators, their student conduct officials, to present students with fundamental due process rights. Like, for example, the presumption of innocence, the idea that students cannot be found responsible student groups until there's a finding of guilt, finding of responsibility of fact. And one of the ways we start this process is through disciplinary charges, right? Accusations. Many of the accusations against Greek life organizations nowadays are unfortunately anonymous. They are submitted through university hotlines and other tips. And this poses pretty serious due process issues for these groups because anonymous reporting prevents the group from being able to confront their accuser. It prevents the group from understanding, in some situations, the full extent of the accusations against them. And without understanding these charges, up being able to really figure out what they did wrong and what policies they're accused of violating, this can really harm the group's ability to contest the charges, to present a defense, and to really figure out what happened here. So when it comes to the gold standard due process, we urge universities and urge groups to advocate for reporting that is not anonymous. That the complainant has to get out there and make their voice heard, identify themselves, unless there is a really serious threat to their lives or safety. Anonymous reporting is generally discouraged for due process reasons, for good reasons, I would say. You can go to the next slide. And yeah, I believe the next slide we have talks about we have, what is it? I think it was interim suspensions. Yeah, interim suspensions. This is a big issue facing Greek life. We have these groups being suspended, being de-recognized before there's a finding of responsibility. And again, the presumption of innocence, this core due process right, applies fully to student groups, guaranteed by Cornell's policies. And these interim suspensions, they're punitive, and they're really designed to they they should be limited, right? They should be limited to the extent to protect the university's interest in preserving the safety of their students, right? The interim suspension, they're a drastic remedy, a punishment before due process, before the hearing, to ensure the students on campus remain safe. And this requires a preliminary finding of responsibility. However, because it's a drastic remedy, because it's imposed before there is an actual hearing on the merits, it has to be the least restrictive measure to protect the parties. So this is a high standard, it's a high bar, and we've seen this imposed in cases where really there's no allegations of violent or otherwise punishable misconduct here, even cases about free speech. And so we want to hold the university to their standards, only have them impose this policy when there is a serious threat to campus safety and an immediate threat of that. And we urge them to uphold student due process rights by really making this drastic remedy narrowly tailored and least restrictive as it can possibly be. At FIRE, we help fraternities, we help students. Our goal is to do whatever we can to ensure that your rights are protected. And so if you would like to get in touch with us or get in touch with me, you can get in touch at thefire.org/submit a case. We call it pulling the fire alarm when your rights are violated on campus. We get around 3,000 case submissions a year. We have meetings every single morning to determine how do we best help these students, whether it's referring them to a private attorney, having a legal network member get in touch with them to advocate for them at disciplinary hearings, writing letters, blogs, press releases, using public pressure on schools to get them to change their ways. We have good relationships with many universities. We know Cornell, for example, we have contacts, general counsel's office and president's office, sometimes picking up the phone, engaging with them, trying to get them to see our point of view to protect students' rights here. Really powerful tool. So we've been doing this for around 25 years of FIRE. I've been at FIRE for 8 years, working with Greek life. I do this every single day. It is my dream job. I do love it. I was a former founding father of the Pi Kappa Alpha fraternity, so I understand how difficult it is to get a group off the ground, out of a colony, and get its charter hanging up in the school library. So it's my pleasure to work with Greek life organizations like the ones at Cornell, and we're gonna do everything we can to defend student groups and their rights. But the first step for you all is to let us know, because we're based in Philadelphia, but we work with college campuses nationwide, and we can't defend rights unless we know that they're being violated. So we urge you to get in touch with us. We're here for you. And like I said, we're doing everything we can to help defend these student groups here.
We'll have questions at the end, but I want to ask one very minor clarification, Zach. If
Sure.
a student really had a very tough situation with his fraternity and wanted to submit a case to you, do you ever take on cases without disclosing the specific student's name to the university?
We don't. When it comes to the cases that we take, it's important for the student to identify themselves to us, that way we can verify the information and present our best case to university. The university can challenge us on our facts and challenge us on our law. Best thing we can do is to make our letters and our advocacy as accurate as possible. So if there is issues of that require anonymity, we can try to work with that. But in general policy, if the students want our help, they have to work with us, identify themselves, give us the available information that we can make the best possible case for them.
But in some cases, you might not identify the specific student to the university. Is that what you're
Yes.
saying? Oh, most of the time you do.
Most of the time, if it's for a student group, we can work with that. If it's individual students fearing retaliation from the university, we can simply work with the group itself through their leadership, and that way you can shield individual students in that regard.
Okay, great. All right. Well, I guess I'm next up. Thank you, Zach. I want to change the slide here, but it's giving me problems. It's not allowing me to. There I go. Okay. Sorry. I want to talk to you for a minute about the North American Interfraternity Conference and its standards. And we abbreviate that as NIC or NIC. And this is very important organization because it provides the sort of insurance and certification of each individual on-campus IFC. So the Cornell IFC is a member of the NIC and also buys its insurance through the NIC. So there's an extra incentive for you to live up to NIC standards because you don't want to put your insurance and everything else in jeopardy. And it turns out that the NIC set standards for Greek adjudications. And from the liability perspective, it is very bad idea for an IFC to violate those standards when setting up its conduct process. The standards can be found at this website, nicfraternity.org, organization conduct adjudication principles. And I would urge each of you to go out and look at those. And the two that I find most attractive and of interest to us here today are that notice of charges must be given to the accused fraternity at least 7 days in advance of the resolution meeting or hearing. So no surprises on the way walking into the hearing room. And the other one is that there's a time frame for holding the hearing, which is 25 academic business days after the charges are developed. And this also is the outward bound on how much an interim action can be. As you know, in October 2022, we had two fraternities, each of which was accused of, shall we say, the roofie episode. And they both were kept, they were immediately put on interim suspension pending the hearing. And then Cornell continued to investigate for over a year, so all the way into fall of 2023, and then couldn't prove anything regarding those charges. And the way they disposed of the two cases was develop some very trumped up technical violations for each of the two fraternities and essentially forced them to plea bargain. And the plea bargain entailed a 3-year suspension with no credit for the year they served while it was being investigated. So in my mind, the power to suspend for an indefinite period of time is the power to destroy and is the power to coerce people into settlements they don't feel are equitable or justified. Yet, absent some time frame like the 25 business day rule that Nick recommends, that's exactly what you have at Cornell and a number of other universities. The other point I want to make is that, according to Nick, loss of chapter recognition should not exceed the term following the undergraduate graduation of all of the existing collegiate members of the chapter at the time of the final outcome. So let's suppose you do have the case of sophomores, juniors, and seniors all being members of a fraternity chapter, and it is found guilty, and the sentence is suspension. Well, instead of suspending them for 5 years or 8 years, essentially what Nick is saying is the maximum should be 3 years. So you wait the semesters it takes for all those bad actors to graduate, and then they can start recolonizing. And so essentially they believe that the maximum penalty should be roughly the 3 years, perhaps less if only juniors and seniors were involved. And the one thing I can't emphasize enough is, obviously, the current Cornell Conduct Office and the current student code and student code procedures do not comply with NIC standards. So it's very dubious in my mind that we're being forced off of the Greek standards onto the student code and procedure without it complying with NIC standards. It puts us in a very difficult spot. I just want to outline a few needed reforms to Cornell's current processes. And again, we're committed to having a complete retrospective review of everything that's happened since January. And I'm sure that many other possible improvements or remedies will come to mind. And I welcome everyone in the audience to chime in on what they think are good improvements and reforms. But these are some that I think are extremely obvious. The first one is the standard or burden of proof. Today at Cornell, under the student code, and this wasn't the case before we were swept under the student code, individual conduct is judged by a clear and convincing evidence standard. If the conduct office wants to convict an individual of some violation of the student code, it must be shown with clear and convincing evidence. In contrast, inexplicably, a different rule applies to organizations, and there the preponderance of the evidence test is used. So it's 50% plus a feather. If it's just teeny bit more likely than not that the organization did it, they get punished. And that strikes me as very odd that a lower standard would be applied to the organization than its members. The purpose of the standard is to guard against false accusations and in part bias of the hearing panel or the hearing officer. And by weakening that standard, you do nothing to improve a sense of justice at Cornell. If anything, you detract from it. And you add to a chilling environment because many of these organizations are involved in expressive acts. The next one I just want to briefly mention is, and we've been trying for 2 years to develop this, we need a document to explain when and how cases are to be handled by the AIFC process or the tri-council process versus the student code of conduct, and quite honestly, versus the downtown courts. We really need a flow chart, a prescriptive document that everybody can rely on it, instead of just having this smoke and mirrors that confuses people as to when things go to the conduct office and when they go to the VP judicial of the AIFC. The next thing, which is very important, is we need criteria for establishing group culpability versus just individual accountability. And if you remember and think back to the recent trial in Manhattan of the Donald Trump organization for violations of the criminal laws and the tax laws, just before that trial started, the DA came out with a document setting forth the office's policy as to when a corporation should be indicted in New York. Similarly, there are Department of Justice documents like that, and you can come up with a checklist of criteria. Like, were all the officers involved? How many of the officers were involved? How many of the members were involved? Was this an undertaking clearly designed to benefit the organization as opposed to some of its individual members? You can imagine a situation where, for example, you have some house in College Town, and all 5 members of that house, occupants of that house, are members of the track team, and they're also members of the Glee Club. Well, if that house gets into trouble and those 5 people violate the student code, do they get prosecuted as 5 individuals? Do they go through it as members of the sports team? Or do they go through it as members of the Glee Club, implicating perhaps criminality on the part of the entire Glee Club? That's guilt by association. That is wrong. And this needs to be cleared up by coming up with clear criteria as to when a entire organization is implicated in a conduct process as opposed to just individual members of that organization as individuals. Next, we should minimize the possibility of duplicate adjudications at the AIFC, the Office of Student Conduct and Community Standards, and the downtown courts. Excuse me. Liam will tell you the technical term is not double jeopardy. It's repeated litigation, and it's particularly offensive to due process because many times what you say in one forum will then be used against you in the other forum. So it's a way of sort of whiplashing some undergraduates who don't have the sophistication and perhaps the benefit of counsel. I should point out that when you are accused before Cornell, you do have the benefit of a team of 7 volunteer law students called Respondents Code Counselors who are very sincere in trying to do a good job for those accused. Then the final reform, I think, is very important and makes a lot of sense, is that as indicated under the current student code procedures, there's a 3-year maximum on suspensions. If you're found guilty, the worst they can do to you in terms of suspensions is order a 3-year suspension from Cornell. But with organizations, there is no maximum. And for many specific violations, such as hazing, there's a 3-year mandatory minimum. And that makes no sense at all to me. We should have something comparable for both. I'm going to mute Tony here. Okay, so you should have a 3-year maximum for both individuals and organizations, and that keeps you in touch with Nick and in tune with Nick. 3 years is a lifetime for any undergraduate, and certainly suspensions of longer than 3 years could be a real death sentence. Just look at, for example, SAE, where I think they were gone for 8 years on their suspension. It just kept on getting lengthened. So that brings up another demand that Nick really demands, which is when you set a return date for a suspended chapter, the university should honor that return date. You don't want to have it be this mirage that always keeps being X years in the future. We should really give people certainty so we know when they can return. So those are my reforms. I now turn it over to Liam Murphy. The microphone is yours.
Thanks, Bob. First of all, I'll ask everybody's indulgence. I'm a late add to this presentation, so just bear with me. Second, a little bit more on my background. As you can tell, I graduated law school in 1988, so I've been practicing for a little bit more than just the 20 years. I think we're 35 and counting at this point. And I'll make the usual obligatory lawyer's joke. I keep practicing because I haven't gotten it perfect yet. My fraternity background is pretty wide. I too was a founder of a chapter. Zach, I founded the Brown chapter of a group called St. Anthony Hall, or Delta Psi. I have served that group as its president of its alumni group. I've also served as the national president of St. Anthony Hall. And I continue to serve in several national level organizations. So I really kind of run the gamut. So I've seen many of those issues, not only from the perspective of an undergraduate member of a chapter, but also as in the very position that many of you are, which is an involved alum. And I thought it might be helpful to, especially given and then of course I've been practicing with Bill Shaw, who's on the phone here, on the line here, for over a dozen years, and we as many of you know, do quite a bit of this kind of work, and we help fraternities not just with their various college code of conduct issues, but we also help them with good business practices, presentations to the undergraduates to help them understand the concepts of group liability. We help them with their various charitable efforts and help organize all of that, and help also maintain good relationships between the alumni and their undergraduate members, which are key to surviving on the current college campuses. So let's talk a little bit about where the Cornell process stands today. I'm going to take us out of the kind of higher level issues that Zach and Bob are talking about in terms of what should a good process look like, and just talk today about what is the current Cornell process. What can you expect? What kind of defects can you see? What to expect when you're expecting, so to speak. I'm going to start off by kind of giving a shout out to Cornell, believe it or not. I mean, I know a brown guy doing that is amazing, but it has gotten better over the time that I have been working in this sphere with Bill. Particularly since the advent of the Code of Conduct, we have seen the growth of something called the Group Behavior Conference. We have seen a lessening of the automatic knee-jerk 3-year suspension for just about anything. We've actually seen them use several times the alternative dispute resolutions laid out in the Student Code of Conduct procedures, which we had never seen before. It was everything either went to a hearing or your plea bargain. And generally the plea bargain was, you're going to do it our way. So we are seeing a genuine effort on Cornell to try to talk and to try to approach many of the more minor violations from an educational angle. This is not to say that we necessarily agree with the approach, but we are seeing greater flexibility and a greater willingness to entertain other options than the knee-jerk suspension. A couple of things on that. The group behavioral conference, which is currently being used, and you need to understand where it fits. The Code of Conduct contemplates that there's going to be a formality, a formal complaint, a formal investigation, the creation of a record, and a formal hearing in front of a hearing panel. As an alternative to that, the Code of Conduct procedures lays out an alternative dispute resolution mechanism. You will look for in the Student Code of Conduct procedures the phrase group behavioral conference. You will not find it. This is a creation of the Standards Office. It's a good idea. However, warning, there are no written rules for that. And that would be something that I think the AIFC might want to seriously think about pushing for, some rules around the process. A process governed by unwritten rules is rife, opens the possibility for abuse. What I thought I would do is very briefly take you through each of those processes, so you have an understanding. But my summary is not a replacement for sitting down and reading the rules. That's very important. In the formal hearing process, you do get a formal complaint. It generally is, that complaint is generally brought by somebody at OSFL. It will be bare bones. You will want it to have time, date, and place specificity, that so-and-so, engaged in X activity which constituted hazing at Y time. You're not going to get it. You might get a date. You're not going to get much more than a date and time, and perhaps somebody was being made to eat inappropriate food or was suffering mental harm. You're not going to get a whole lot more than that at the complaint stage. What will then happen is a series of interviews. Now, the interviews, they can interview any student, and one of the defects in this process is the contract that a Cornell student, quote unquote, signs when they accept Cornell's invitation to become a student there. That contract requires them to speak to the university in a code of conduct situation, or face another charge for failing to speak with the university. If, for example, to take this to something close to real life, you are a Cornell student and you commit a murder, Cornell can say, I want you to come in and talk to me about the murder. And you are required to talk to me, and that is not necessarily, you don't have a Fifth Amendment privilege in that process because Cornell cannot prosecute you for a crime. As a technical matter, emphasize technical, as a technical matter, the DA could then subpoena those records from Cornell. There are a whole bunch of problems with the DA doing that, not the least of which is federal education privacy laws. But it is technically possible, and you can see why when if a student really thinks they've committed a crime, there becomes a problem. And we have, in our practice, sometimes guided people to either not talking to Cornell or emphasizing to Cornell that the speech is being coerced by the Cornell Code of Conduct. And I can see Zach nodding his head on that one. But that's one of the first sensitive issues. So Cornell will come in and do its own interviews, and often those interviews will happen before you've even found out about the investigation. The right to have an advisor is in that process. Now, I want to emphasize again, this is the Cornell process. This is the process that you have signed up for by the contract of being at Cornell. You don't have a right to a lawyer, so to speak. You have the right to an advisor. Cornell does everything it can, and not to throw a stone at Cornell, every college does everything it can to keep lawyers out of the process. So it becomes important to identify who, and every person is entitled to an advisor and a support person. That applies to groups as well. Bob mentioned the Office of Respondents Code Counsel. These are they are trained law students, but the reality is that their purview really extends to people who are getting into problem with, partying too hard, academic plagiarism, academic conduct, that sort of thing. There is a place for them in this process, and there can even be a place for them in a large investigation, but they don't often have experience in a complex set of charges. So bear that in mind. When you're in the Cornell process, there's a series of New York cases that talk about this. We often want to talk about due process writ large, and there's a place for that, but there's New York case law that says you don't really have a due process right in these proceedings. And that's why if you look at the Code of Conduct, again, Cornell talks very clearly and definitely not about due process, but about fundamental fairness. And I will save for another time that careful analysis which due process and fundamental fairness do require. But focus on fundamental fairness rather than due process. Now, when you get to again, a formal investigation involving an organization, the organization has the right to request an advisor and a support person. Cornell takes the position that the advisor can only advise the officers of the organization, and that Cornell reserves the right to interview members as witnesses without an advisor present. And what Cornell will say is, well, I'm not going after that individual student, and therefore a person who's a mere witness and not a respondent to a charge has no right to an advisor, because after all, they're not going to get in trouble. So just be aware of that. So when we're doing an investigation with Cornell, we're allowed to sit in on the interviews of the officers, but we're not even told when the members will be interviewed. So again, communication becomes a very, very important thing. Understand in these investigative interviews, there is no cross-examination. Whoever sits in on them cannot ask any questions. If you start asking questions, you are invited to leave. So that's a very important thing to bear in mind. The place, by the way, footnote, the place where you can develop your own piece of that is to do your own investigation, produce your own transcripts, produce your own affidavits. And there's a time and a place for that, because all of these investigations are recorded, they're transcribed, and they're put into a large thing that the poor chapter president has to read and amend on a very, very short time frame. We're talking several hundred pages and generally given about 5 business days to go through it, which is terribly unfair, but there you have it. Draw a distinction, please, between the standards office and the Title IX office. They are entirely separate offices. They do not share office space. They do not share personnel, and there are different rules. So, for example, in Title IX right now, you are permitted to have some limited cross-examination of both witnesses and complainants, and that's an important right to be used. Keep my eye on the time. So I'll leave you with a few thoughts about investigations. Evidence and standards. There's a very poor understanding of both evidence and standards exhibited not only by the old Greek judicial board and this training that was given to them, which is rather poor, but also really frankly among the investigators themselves who vary widely in their ability to question. We still hear questions, is it possible that? Anytime somebody, any of you or any of your undergraduates get the question, is it possible that, the answer is, with God, all things are possible. We're not talking about possibilities, we're talking about probabilities, and even then we should be talking about evidence. Hearsay. There's very little training given to the appropriate weighing of hearsay. Lawyers will say that in fact, there's a famous lawyer who said that the rule really shouldn't be that hearsay is not admissible. The rule should be that hearsay is admissible. It's just given little weight. Just because somebody says something, it doesn't mean it's so. The notion that evidence needs to be corroborated is often ignored, and this is why anonymity gets more weight than it deserves. And the notion, Bob, I thank you for saying this. The training used to be, it's 50% and a feather, is really an inaccurate representation of what that preponderance of the evidence standard is. It's really a misnomer, and it just goes to show how poorly trained the Cornell people, the Cornell students were in that old process. Be wary. Very often we've seen investigations where Cornell cannot prove the initial complaint, but find something else along the way. So be very, very wary of that. Bob raised, and it's a good point. What makes it a fraternity event as opposed to a sports team event? Isn't it interesting that despite the wide breadth of things that were alleged in last month, doesn't seem to have hit any sports team but it is interesting, of course, that they've been going after the business fraternities. Do be careful about information that crosses into the criminal conduct area. If you hear of your undergraduates doing something that's truly criminal, you probably do need to be talking with a lawyer type. One of the things about timing, so there are issues with timing in the system. It is something I've seen repeatedly, that often investigations drag into exam period. And in fact, I question if this is going into exam period, what's the mental health impact on members of any student group? And isn't it ironic that in several situations we see students being pressured to make a decision on a quick basis, and then because of the power imbalance between the university and the individual student. And one of the things they're talking to us about on hazing is a power imbalance. So it's ironic that there's a certain blindness there. Last thing, there are numbers of issues with results. It's hard to compare results. And of course, it's made all the harder because there's been significant change in this process 3 times in the last 5 years. So it's very hard to say, well, this is, and Bob again raised the issue of Sammy and earlier suspensions that were for multiple years. How do I compare something that was decided under an older process with this newer process? Bob, if you could move to that last screen, please, the 12 things. And I'll take us through that quickly, and then we can go to questions. Here we go. 12 things to think about in a conduct case. Prevention is your best defense. Build rapport with your undergraduates now. You should know your undergraduate president. They should know your number. They should recognize it and pick it up on the cell phone. Be sure that they will call you when trouble hits. They should wake you up at 2 o'clock in the morning so you can be the first to know. If they don't know you well, you're not going to be the first to know. They're going to be calling their parents and somebody else. Be involved in your membership process. Understand what's going on with their, for the rush period. Understand what's going on for their new member education period. And by the way, leave them with the impression somebody may drop by. It happened in my process. An 85-year-old former president of the fraternity just stopped by the house right in the middle of a rush event. It was great. We had a great time. But undergraduates who understand that can happen are far less likely to engage in groupthink. Have a clearly identified alumni contact and a crisis plan. People should know what to do. Know your insurance. Read your policy. Say to the undergraduates, if you engage in underage service, you're not covered. So it's going to be knocking on your folks' door, not mine. And again, that gets down to read. Read what your national says. Read what your policy says. Read what the rules are. Know it ahead of time. If you get into trouble, conduct your own investigation. Cornell's not going to share theirs with you until it's too late. And consider, in the context, and of course everybody's got their own context, their own living arrangements, their own national, their own set of circumstances, but sometimes it can actually be advisable to suspend the chapter yourselves so that you can say to Cornell, we got this. We got this. We don't, no offense, we don't need your help. We'll get back to you when we take them off suspension. If Cornell thinks that you really are taking a responsible position, they will sometimes back off. Bob notes with the recent revisions to the AIFC process, maybe it can be handled internal to the AIFC. That's no guarantee that Cornell is going to back off. Again, depending on your national, your relationship with them, what their policy is. Again, context is everything. But make sure that you're not leaving open the possibility that Cornell uses your national against you. When in doubt, prepare for your meetings. We take the time when we're going through the formal investigation process to prepare the students as though they're going to be sitting for a deposition. Now, we're not telling them what to say. We're just helping them understand that this is not your normal conversation. We're helping them get through that, which is helpful really to everybody. It helps the process go faster so you can get out of it. It also helps make sure that we're focused on what Cornell's original allegations are, teaching kids how to listen to the question, answer only the question with the shortest possible truthful answer. Which means, of course, even as an alumnus, think before you speak. Sometimes you can create more problems by trying to be expansive. Understand, kids will be kids doesn't work anymore. And this gets back to my point about due process, fundamental fairness, double jeopardy. I've heard it all. Don't make the mistake of arguing your federal case to Cornell, because Cornell's not the judge you really want on that. With that, I'll thank you for your attention and be open for questions.
All right, well, there's the React feature, and you can raise your hand.